2016 and is countersuing. With that, let's head back to court and see more testimony.
And it's hard for me to get a sense, are they following? So I apologize if I repeat some questions. But
no, go right ahead.
As I understand, you believe Mr. Sanderson is one of the rare patients who experiences concussive symptoms beyond 18 months. Is that right?
I wouldn't say rare. He's in the minority. Less than 5% fall under that category. So rare in medical terms is less than 0.1%. And that's based on pharmaceutical studies. So it's really not rare, but it's certainly in the minority.
Okay, I appreciate that clarification. I was just using it in a kind of colloquial sense, but
understand.
But that's obviously a very small minority. 95 versus 5, obviously, it's a huge disparity.
20 to 1. 20 to 1.
Got it. Okay. And it seems like you base this opinion on the post-concussive syndrome. Is that okay to call it that?
Yes, syndrome is a compendium of symptoms.
Okay.
That's the definition of syndrome.
Okay, so maybe we could just say you base your opinion on the persistence of his concussive symptoms.
That is correct.
On testimony.
As far as it being permanent.
Right.
I mean,
okay.
He had a mild traumatic brain injury day one. The question becomes, is it permanent or not? Only time will tell. You see?
Right.
And then
yes.
The medical records provide that timeline.
Right. And so you point to the medical records and then testimony from family members or friends that knew him before and after as the evidence supporting this post-concussive syndrome or persisting symptoms opinion that you have. Is that right?
And Mr. Sanderson, because I saw him.
Oh, correct. And your evaluation of him.
So that answer is yes, to include.
Okay. I believe in your deposition you said that you thought Mr. Sanderson's narcotic medication might have exacerbated his symptoms following the collision. Is that right?
Narcotic medications can definitely make, in layman's terms, anyone a little goofy, if you will. So you can certainly have exacerbations of certain behavioral elements, if you will, from narcotic use. It just depends. I would have to defer that to the treaters because they're the ones that prescribe that to them, and so they would have a working knowledge of how that medication was affecting.
Okay. And then in your deposition, I think you said that you did not refer to the fMRI, not MRI, but fMRI in any, you didn't use that in formulating your opinions at all. Is that correct?
Yeah. The F, the small f in front of the MRI means functional MRI. I do not use that in my practice, nor was I trained in that element, and therefore I don't use it in my practice, and I defer the use or any opinions from that device to others.
Okay, thank you. Okay, I want to go through, as plaintiff's counsel did, I want to go through and just make sure I have a good sense of what you reviewed to formulate your opinions for the deposition that I took. So I'm going to just go through those real quickly.
So what page are you going on, my? I think, what, page 13, I think it is.
Sure, I'm trying to. I don't have it. I have kind of some notes here. I don't have the deposition transcript, but I can definitely. Page 20 is where some of this occurs, and then
page 14 has a lot of it too.
Sure. Okay. And then page or exhibit 3 to your deposition.
I don't have any of my exhibits.
Yeah. Maybe I'll pull that up because that will make it more simple.
I think that would be helpful since I don't have it.
Okay. So when you gave your opinions to me in that prior deposition, and as you said today, those are all the opinions that you have provided in your
there you go.
testimony.
Now, I do have that page, but if for some reason my copy does not have an exhibit sticker on it, but
Oh, that's okay.
And that's what I read into the record today. So that's I have that. Yes.
Great. So I'm just looking at that deposition section at the bottom, and it lists out the people whose testimony you had read in preparing your opinions.
That is correct.
And I'm just going to note a few names that are not on that list just for clarity's sake. So Terry Sanderson himself was deposed over multiple days. You did not read those transcripts, correct?
Not before that first deposition. That is correct.
Right. And you did not read GWYNETH Paltrow's deposition.
No, that is also correct. And I did not.
And then you didn't read Eric Christiansen's, the ski instructor who was at the scene of the collision, correct?
I don't know if I had that before or since, but he was. He reported that he wasn't an eyewitness to the event, so I can't tell you with certainty here. I'm looking at the deposition itself, and I'm seeing if I said that or not back then. I don't recall.
On page 20, I asked you, I said, you haven't read anything from Eric Christiansen, and you said, no, I have not.
Okay, then I had then. Okay, so you found it in my deposition.
Yeah, great.
I don't have any direct recollection of that deposition, so I have to refer to the transcript.
That's fine. That's why we take the transcripts. And then another name that is not listed here is Carrie Oakes. She was another ski instructor who was at the scene. I don't see that she's listed here. So you did not read hers.
I don't recognize the name. No.
Right, okay. And then you did not read Brad Falchuk's, and he is Miss Paltrow's husband, who was also there that day of the collision.
No. I don't recognize that name either, so I'm sure I did not have that deposition.
Okay. And then the same thing for the Miss Paltrow's children, who are Moses and Apple. They were there as well. You didn't read their depositions, correct?
No, I'm not aware of that.
Okay.
Okay, so the neurologist continues to testify. Let's talk about that testimony right now with my two great guests joining me. I have Cassia Early, who is still with us and giving great insight. I also have Catherine Lizardo with me now, trial attorney. Catherine, I want to go to you because during the break we were talking about how you handle cases dealing with TBIs or traumatic brain injuries. What is some of the experiences that you've had? And based on that experience, what do you think of the testimony that we see right now?
Yes, my background is on traumatic brain injury, also severe and even mild traumatic injury. And those are real. Even if you have mild symptoms of brain injury, that is still brain injury. And it does sound very grave because if you have those, it significantly affects your daily living. These, what we're seeing right now from this neurologist is what would typically happen if you do have those kinds of brain injury. You get examined as to how you're functioning. But what we need to think about with this expert, and the question that was just being asked to him is, because he's designated, which means his opinion is limited to being a biomechanics expert and not a neurologist, he didn't read the witness's deposition, which means he doesn't know what those eyewitnesses actually said. So there's a question as to how did the accident happen and how did that cause Sanders' brain injury symptoms? And it would be difficult to do that without those witnesses' testimony.
Yeah, and Casey, I want to get your take. You know, when you have an expert witness on the stand, you as an attorney, when you're dealing with cross-examination, you have to really tread lightly. You never want to be in a situation where the expert is sort of schooling you, and it appears that you're losing the battle of cross-examination with an expert witness because by nature they may be just more well-versed in that area than you as an attorney. But so how do you handle that? Of course, there's preparation. Preparation is key. But when you are dealing with an expert witness on the stand and they are well-schooled in the area they're testifying, how do you break through and cross-examine them effectively so that their opinion may be thrown out by the jury?
Well, the role of cross-examination is to limit their scope of expertise. So in this case, just as my colleague stated, he's a neurologist, but he's testifying in a different area or field of practice. Also, he's testifying as to what he believes or how he believes this accident occurred. He's not even an accident reconstructionist. So this is the purpose of the defense counsel's filing of a motion in limine to limit his testimony and his ultimate opinion, and or raise that objection to the court to preserve on appeal, because you don't want the jury to, number one, accept him as an expert, and then anything that he testifies to, they'll accept as truth. So make sure that he's only limiting his opinion to what he is qualified to, and then also bring out the fact that he doesn't have the full scope. He doesn't have all the evidence of witnesses to testify, because he just admitted that he didn't read or obtain their deposition transcripts.
Yeah, Kesia and Catherine, great analysis there, but we're going to take a quick break here at Law and Crime. Stay tuned. When we come back, more coverage of the Gwyneth Paltrow